We'll begin looking at a few marine casualties involving fatalities, then some criminal cases based on international conventions, including some of the MARPOL cases, but of course relating to safety incidents and marine casualties. And then we'll take a look at what can we do to help avoid these problems, and hopefully some tips that I share along with what Mr. Gaitas shared with us earlier will help us all keep sailing smoothly and avoid any incidents with the Coast Guard or any other jurisdictional body. So one of the biggest incidents in the United States was, of course, dealing with the Deepwater Horizon and the Macondo well blowout. Of course, this is a very different industry than what most people here are involved with. But I bring it up for a couple reasons. The first is that BP, the company itself, was charged with a variety of crimes and ended up settling for the largest criminal fine in United States history, $4 billion. And the thing to take away here is, not that this is some kind of risky operation in the offshore. I think the big takeaway here is that where there's a loss of life or some kind of newsworthy or catastrophic incident, there will be an appetite for enforcement. Prosecutors, enforcement officials will want to do everything they can to send a message, both through the media and to the industry as a whole, that they are looking at this very seriously, and that will mean penalties. As a side note, in the U.S. Department of Justice, the agency in the United States that is responsible for prosecuting marine crimes, including the MARPOL cases, also has jurisdiction over safety enforcement, not only in the maritime sector, but other sectors. So organizationally, there's also the crossover between safety as well as environment. So these are not things that we should look at separately, but I think rather together. So in addition to the company, lots of people were involved and faced criminal liability, which is a theme that we'll see in other incidents that we look at, including supervisors, technical people, and some people faced charges stemming to their behavior during the investigation. For example, Mr. Nix was accused of deleting emails relating to the investigation. So in addition to being very careful, as Mr. Gaitas said, about what you send, you also have to be very careful in how you maintain records. God forbid there is any kind of investigation. Another incident from the United States dealt with the Queen of the North, which was a Swedish flag vessel. And one very interesting thing about this had to do with the coal regs, the collision regulations. And the instructions that the jury received relating to this was that following of the coal regs was a standard to be used for what a reasonably prudent mariner would follow. Of course, following the jury trial, the person that was navigating was found not to have followed them, and was subsequently convicted. The MV Sewol, a very tragic incident from South Korea, huge loss of life, huge media coverage in South Korea, had very large political ramifications. And again, similarly to the BP incident, this was not just limited to the captain or a couple people. Vendors were involved, the chief engineer, of course, the CEO of the company, as well as inspectors. So the criminal liability was very wide-ranging in this case, and even those that were not convicted or not ultimately charged had to go through the ringer, as we say in the United States, in terms of proving that they had nothing to do with it. One very famous, unfortunately, infamous incident from here in the Mediterranean region, Captain Schettino's infamous salute ended up getting him 16 years in prison, as well as shoreside officials, the company, and other folks involved in the operation of the Costa Concordia. Some of these penalties for people like, for example, the crisis director or those involved in cabin service ranged from 1 year to 2 years and 10 months. My understanding is under Italian law, some of these penalties are commuted or reduced, so folks on the lower level won't face very much jail time, if any. But still, again, similarly to BP and the Sewol incident, we see multiple layers of civil liability. Now, now looking at similarly to what Mr. Gaitas was talking about, some of these cases have criminal liability that stems from MARPOLs. MV Rena, a Greek-owned vessel that grounded on the Astrolabe Reef in New Zealand, oil spilled, and criminal sentences follow. The MV Full City in 2009. Again, both safety and environmental issues here. The master and the third officer faced prison time. In Asia, we have the High Bay Spirit, crane barge that broke free and collided with a vessel. Criminal liability stemmed from that for some of the mariners, some of whom were Indian citizens. This led to a very large diplomatic incident in Asia and attracted the attention of many seafarers organizations regarding the treatment of those sailors. In the United States, we have several criminal cases, most of them stemming from MARPOL. A couple safety-related prosecutions have occurred. US v. Noble Drilling, again, primarily an environmental issue, but one of the issues there was failure to report the casualty. Similarly, in US v. Egan, there was a barge in the United States that was traveling with combustible vapors on board. This caused a death and led to a conviction under a safety statute. So again, anytime that there's any sort of major catastrophe involving especially loss of life, if a prosecutor can enforce some sort of safety statute or find any kind of major penalty to prosecute, chances are they will. So, Dinaganme, what should we do? The Coast Guard recently issued a NAVIC, which is very relevant not only to US flag vessels, but to any vessels trading in the United States. All vessels within 12 nautical miles, and also especially for tankers, this applies within 200 miles. And the reason that this existed, that this NAVIC came out last year, was there was a lot of confusion in the industry about what should be reported, how should it be reported, and the industry worked with the Coast Guard to request this clarification, and it was issued. Its intent, of course, was to provide clear guidance. Of course, sometimes with the Coast Guard, clear guidance can be a fuzzy term, but the main advice is really, if there's any doubt, get in contact with the Coast Guard, with the officer, with the OCMI, and it's not even necessary to report, but the advice that was given is to check with them whether something is a casualty. But the subsequent advice that they've also given is, if in doubt, report it. And a notification really is the first step, and then if necessary, within 5 days, a formal report can and should be issued if it is indeed a marine casualty. And some of the definitions that were included involved defining of an injury, what is exactly a casualty. A lot of times it's clear, but if it's not, again, if in doubt, it's better to report. So, are we looking at the new MARPOL Annex 1 prosecutions relating to safety? I don't think we are. I don't think it's the number of safety prosecutions, as you saw, that were purely safety related are very small, but the two go hand in hand. So I think what's very important to do as far as risk management, most vessels have a vessel response plan, but in our experience, very few companies have a management response plan. That is to say, what are senior level officials, people on the ground, going to do when there's a casualty. And in a casualty situation, of course, everything is very fast-paced. It's important not to lose time. As a gentleman over this way mentioned, it's important on the corporate level to understand what to do, not only on the vessel. So I would echo that, and I would suggest that part of that plan should be having the number of defense counsel handy, on speed dial even, but at the very least within a plan. And of course, at Blank Rome, we have a maritime emergency response team. We're available 24/7, and as you can see with the little Greek flag, there is even a Greek speaker on board now. So I think that is one of the key things. So to sum up, safety is an important consideration, even though we're not seeing the level of prosecutions that we are for the MARPOL cases, and I don't think we will unless something changes at the IMO and then subsequently in the US Congress and other places around the world. It's still a very important aspect in terms of defending a company from liability as well as any sort of related safety violations.